To our esteemed delegates, international friends, the CEO and Chair of the Chartered Institute of Payroll, my name's Jade Linton, and I have been assigned the enviable task of condensing 12 months of employment law into 25 minutes. I'm good at a lot of things, but I don't know if I'll quite cover that. So I've cherry-picked some areas for you, which I hope you will find useful. And if you don't enjoy anything about my session for the next 25 minutes, can you please at least give me a little hand clap at the end for matching your corporate colours? Thank you. Thank you. Thank you. That's no easy task. So hopefully my slides are up. That's me. Okay. Calling all payroll professionals. So 2018 has really been a year of mass activity around pay equality or pay inequality, depending on how you look at it. The gig economy, workers' rights, and tax. And I'm not going to talk to you about Brexit, and I'm not going to cover GDPR. And I promise that's not because of the subtle threats I received yesterday that I better not cover it in my talk. But I'm aware that you've already had some engaging and some insightful talks on GDPR and Brexit. Some of them I've been privileged to attend. So I don't want to duplicate that content in our update today. If anything, I'm just hoping that what I share with you will cause you to think, just to give you some little nuggets on the employment law update that you can go back to your respective departments and think about and add some more detail to as time goes on. So my objectives today will cover the equality pay update, we'll touch upon modern working practices and the changes there. We'll touch upon taxation of termination payments, including how that might work in practice in an employment scenario. And then I'll end with an overview of changes in 2018. And I emphasize that is an overview. You've had a very detailed legislative update. So I'm just going to provide perhaps a cherry on top for you in the employment field. So buckle your seatbelts and let's begin. Gender pay gap reporting. So last year, I believe I predicted that on the horizon would definitely be ethnicity pay gap reporting and disability pay gap reporting. And today, the government have announced that they will start a consultation into the ethnicity pay gap. So smart employers should start reviewing their practices now because the spotlight is about to be upon you. And the worst culprits, not my words, but that's how they've been described, SMEs, those with less than 250 employees, the spotlight's coming your way as well. So this is really an opportune time not to bury your heads under the sand, but to get prepared and have a look at the differences now and see if we can remedy them. So as you all know, from 2017, any organisation with 250 or more employees had to publish data and report specific figures about their gender pay gap. We're going to look at some of those reports and what they tell us. So in April 2018, we saw the first of those reports in the private and voluntary sector. And the Office of National Statistics reported that mothers were still providing 74% of childcare. And you might have a male and female who start work together, and as soon as they start work, so day one, that male may be at a 10% advantage to the female. But by the time that woman may choose to have her first child, by the time that first child is 12 years old, the gap is growing more sustained and wider, hence the need for this reporting, to the extent that a woman's hourly wage are a third below that of men. So what have the reports told us It's all well and good having these reports, but what are they telling us? What can we do with it? Well, we can see from the reports that have been published so far that there's still a lack of well-paid part-time and flexible work available. We can see that there's a need to recruit more women into senior roles. But it's not all doom and gloom. Unlawful inequality pay in some cases, but not in others. Anyone in here from the construction industry? I see a few hands up. Well, you fared quite well in the gender pay gap reporting. And finally, fewer women working in highly paid professions such as STEM, science, technology, engineering, and maths. So now that we know and it's giving us some data, perhaps we can start enlisting the changes required to narrow that gap. So some examples, I've read these with keen interest. The first one I'll touch upon is Apple. So before I name and shame, there's not anyone in here from Apple, is there? Good. Okay, let's go. So Apple, said to be one of the most successful companies in the world, describe themselves as dynamic, forward-thinking, fast-paced, and yet 71% of its top-earning employees were men. Men were paid more across each of its 3 separate entities, which included Apple UK, but yet, surprisingly, in the retail sector, the pay gap was much narrower, 5%. Hurrah for Ryanair, anyone? No? Okay. Ryanair was by far the worst performing airline, and we meant to type worst performing airline with gender pay, not just generally. Reporting a pay gap of 72%, with women making up only 3% of the top quarter of its high earners. Only 8 of the airline's 554 UK-based pilots were female, whilst it was women who made up the greater proportion of its lower-paid cabin crew. So some shameful data there. So where does that leave us? Check your practices now, not just for gender pay. I think it's only a matter of time before we start looking at disability pay gap. Helen mentioned the CEO versus worker pay gap, and so on. Instead of looking at it as a procedural burden, I think it would be wise to look at it as an opportunity for some change, an opportunity to get with the times, if you like. So on to modern working practices. And again, this has already been touched upon, but in the employment context, I want to bring your attention to the Good Work Plan. Now, the Good Work Plan was published by the government in February 2018 and was in fact in response to the Taylor Review, which I've previously spoken about and which Helen touched upon this afternoon. The recommendations of the plan are quite numerous, but 3 that I wanted to touch upon. Enforcing vulnerable workers' holiday and sick pay for the first time. A list of day 1 rights and day 1 employment rights as well. Touching on the employment rights, you may be aware that in order to bring claims for unfair dismissal, you need to have generally at least 2 years' service. But there are more and more calls for day 1 employment rights. In addition, day 1 rights including holiday and sick pay entitlements for all workers. So that's including your casual staff and your 0-hour workers. And also the ability to request a more stable contract, particularly for those workers who are on variable hours, 0 hour, thus giving greater financial security for those on flexible contracts. Which brings me on to the topic that always gives the biggest sigh, and that's the good old employment status. That has really been in the news. Anyone read on the Deliveroo cases? Uber, Plimico. Huge news cases about employment status. Now, the government has finally agreed, although not put those changes in stone, but they've agreed that there should be greater clarity over employment status, and have even gone as far as seeking some information before, including looking into existing case laws, so your Uber cases, your Deliveroo, your Plimico case, which I'm going to go on to talk about, with a view to aligning the tests. So trying to make it a lot easier for us to decide who is an employee and who is a worker, because the rights afforded to those individuals vary according to their status. Traditionally, the question of employment status, it's not just in your terms and conditions. It's not just enough to have a contract saying so-and-so is self-employed, as we'll go on to see. It is very much a matter of fact and degree. The cases themselves can be quite bewildering to understand, and even from a moral perspective, you may be faced with someone who has never paid any tax or national insurance contributions, but yet may be found to be an employee or worker, and as such be able to claim rights stemming back a number of years. And such was the case in Plimico, Mr. Smith versus Plimico Plumbers. Now, Mr. Smith worked for Plimico for 6 years. And in 2011, the parties decided to part company. Mr. Smith successfully argued in the Employment Tribunal, and then on appeal to the Employment Appeals Tribunal, and then all of the way to the Court of Appeal, that he was a worker, and he was successful. But Plimico maintained that he was a self-employed operative. Why, amongst many things? Well, it was written in his contract, of course. So this matter went all of the way to the Supreme Court on the back of Plimico's appeal. And what was the decision? Despite the fact that Mr. Smith filed tax returns on the basis that he was self-employed, was VAT registered, was entitled to reject work, and was able to take on work from third parties, the Supreme Court held that the Employment Tribunal was correct and had been entitled to find that Mr. Smith was a worker. I like the way the Sun put it. They said that Mr. Smith was flush with success. But the decision really shows some important factors around employment status, as I've put on the screen. Mr. Smith was required to wear a Pimlico branded uniform and to use a Plimico branded van leased from the business. He had to carry a Pimlico identity card, and he had to closely follow the administrative instructions of the control room. His contract contained words such as wages, gross misconduct, dismissal, appraisal, and contained a suite, just a plethora of restrictive covenants aimed at restricting his move should he decide to work elsewhere. Even though Mr. Smith was able to swap assignments, he could only do so with other Pimlico staff. So really the substitution clause that Deliveroo was successful in arguing in the first instance, the relationship with Mr. Smith was more akin to shift swapping amongst employees. So that was not enough to secure him non-worker status. The impact of that decision will entitle Mr. Smith to proceed with claims for disability discrimination, for which there is no limit on the amount of compensation he could receive if he's successful, unlawful deductions from wages stemming back at least 2 years, and holiday pay against Pimlico. And in the meantime, there are a number of other cases on employment status which continue to make their way through the courts. I encourage you, All it takes is a dispute between you and your self-employed contractor for them to maybe look at their contract with greater scrutiny and ask themselves whether the reality really matches what is written. IR35 is causing individuals to look again at the employment relationship. So I urge you to go away, and for those of you who are dealing with employees, workers, self-employed contractors, ask yourselves, does the reality really match what is written? And if it doesn't, do we need to reassess what the intentions of the parties are and get a document drafted that resembles what's really happening? And I've put some examples there of what the courts will look into in deciding employment law status. So what's on the horizon for modern working practices? Now, I don't know about many of you, but I was quite disappointed that tax was outside the scope of the Taylor Review. Now, I am no taxation expert, but I think if we're going to align the categories of self-employed individuals versus employed, we do need to look at how those two categories of persons are taxed. Maybe even redefine the definition of self-employed. To date, there are no plans to deal with taxation differences between the two elements, but I think that would be a really good place to start. Even as an added motivation, the relative growth in self-employment is forecast to reduce tax revenues by billions of pounds. I think the government may or may not be ignoring tax now, but the problems that this causes aren't going anywhere until we actively fix the taxation system as they apply to self-employed and employed individuals. Are you all with me so far? Great, okay, I'll keep going then. Taxation of termination payments. Again, Helen touched upon this, but in the employment concept, the position before April 2018 was as follows. If there was a clause, usually in your contract of employment, an express clause, which allowed the employee to be paid in lieu of notice, then the payment would represent wages and would be subject to the normal tax deductions. If there was no pile-on clause in the contract of employment, but it was the employer's practice to always make payments in lieu of notice, then the term was implied and as such may be taxable. And then finally, if there was no express clause and no chance of a clause being implied, the payment would be regarded as compensation for breach of contract and the first £30,000 would be tax-free. The new rules are set to simplify this position. And as such, a payment in lieu of notice, whether contractual or not, will be taxable. And the £30,000 exemption does not apply to any payments in lieu of notice. So let's see how this might work in practice. After 14 turbulent years of employment, Joseph and your company have decided to part ways under a settlement agreement. The company have waived the requirement for Joseph to work his contractual notice of 4 weeks, choosing to rely on the pile-on clause in his contract, which allows him to leave this Friday. The parties, however, in their without prejudice discussions, agreed that Joseph would receive an ex gratia payment of £30,000 to include his contractual notice pay. What would your advice be? And I want a show of hands here. Would it be a pile-on payment cannot be treated as non-taxable and would have to be accounted for elsewhere in the settlement agreement as a taxable item? Or would it be B, as there is no pile-on clause in the contract, it's fine to include the payment in the ex gratia payment? Or would it be C, as the total ex gratia is no more than £30,000, including pile-on within the sum is perfectly legal? Hands up for A. Okay? Anyone for B? And C? Few for C. I'm pleased to say the answer's A. The majority of you got it. I won't name and shame the ones who went for C. But you've just entered into a without prejudice conversation with Joseph, and you shook hands on the deal that he would get $30,000 tax-free. Could this be achieved in another way, perhaps? So could anything be done to arrive at an amicable deal without Joseph being out of pocket? Who would say yes? Yeah, got a table full of yeses over there. Yeah, and who would say no? Okay, so we've got a few dissents then. Well, the answer is possibly. So under these circumstances, the employer could consider making an ex gratia payment, which would be equivalent to the amount that was deducted from the pile-on in tax. So that might be one way, provided there's been a termination, that could be one way to ensure that that shaking of hands, if you like, and without prejudice conversation isn't conflicted. So on the horizon, again, we've touched upon this. So all termination payments above the £30,000 threshold to class as 1A national insurance contributions, that's employer liability only. And subjecting termination payments above the £30,000 to class 1A national insurance contributions will be implemented in a national insurance contributions bill, which will be published this year, and the change will take effect in April 2019. So now on to an overview of changes in 2018. I might rush through these as many of them have already been touched upon already, but if you wanted to talk about any of them in greater detail, I will be here for the rest of the day. So the Fit for Work assessment ends March 2018. For those of you who may use the assessment, those of you who don't, this was a free information service which provided advice on health, work and managing sickness absence, and a free occupational health assessment service for employees who had reached or who were likely to reach 4 weeks of sickness absence. So that assessment has ended. An overview of further changes, national minimum wage. I won't just simply read out what's on the slide, you can see that for yourselves. But one thing just to mention, your HMRC audits, and for those of you who were wondering, no, they do not get paid commission for fining. But one thing to really be aware of seriously, you may not be in breach of national minimum wage, or not deliberately so, but look at things like your salary sacrifice, of course. Because that could, if you've got several of those, that could bring you dangerously close. The abolition of childcare vouchers, we've touched upon that. In the interest of time, I won't pick up on that again. So what's on the horizon? Number one, restricting employment allowance for illegal workers. Now, this is to be, the date for this is to be confirmed. But in accordance with the government's plans to deter the employment of illegal workers, employers will be unable to claim employment allowance for 1 year if they have been found to have, number one, hired an illegal worker, or number two, been penalised by the Home Office, or number three, exhausted all appeal rights against that penalty. So the draft legislation containing these measures was scheduled to be enforced in April 2018, but that appears to be delayed. So let's watch this space concerning that. Again, as has been touched upon, IR35 in the private sector, Chancellor Philip Hammond said, and I quote, "The aim in introducing this is to ensure that individuals who effectively work as employees are taxed as employees, even if they choose to structure their work through a company." You also have the payslip changes. Again, that's been touched upon, but for the sake of completeness, two important changes affecting payslip information. They will come into force on the 6th of April. Employers must include the total number of hours worked, where the pay varies according to hours worked. So, for example, variable hours or 0-hour contracts. And secondly, pay slips must be given to workers and not just employees. 2020, parental bereavement provision. This is an interesting one. Foundations for which were laid last year, October 2017. The government confirmed its backing for a private member's bill, the Parental Bereavement Bill. This is currently progressing through Parliament and will entitle employees who lose a child under the age of 18 to 2 weeks leave paid at the statutory rate if they have 26 weeks service. Currently, we know that it's a day one right to take emergency time off for dependents, so this is adding to that. It is, of course, you are, of course, at liberty to give greater than the statutory entitlements in your contract. You might have something similar to this already. The item that's still currently on hold, though, and it has been on hold since our dear David Cameron mentioned it in 2015, is grandparental leave. That's still on hold. There's currently a review into the shared parental leave. And out of interest, have there been many employees taking that up? Just a show of hands. I certainly haven't. You know, we spent weeks on end drafting the policies and so on for it, and the take-up has been really small. So that's being reviewed with a view to whether it's rolled out for grandparent leave. I'm not a betting person, but I wouldn't hedge my bets on that coming in anytime soon. Feel free to quote me if next year you invite me again and I'm wrong. And on that note, thank you for having me. And until next time, thank you for listening.